The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Four cases are submitted this afternoon. They are Sioux Pharm Incorporated and Sioux Biochemical Inc. versus Eagle Laboratories and others. Second case is Sioux Pharm Inc. and Sioux Pharm Biochemical versus Summit Nutritionals International Inc. Third case is Iowa Attorney Disciplinary Board versus Cami Eslick. And the last case is Iowa Supreme Court Attorney Disciplinary Board versus Gerald Moothart. Those last two cases are now submitted to the court without argument, and we'll hear the arguments in the first case. Mr. Osborn.
May it please the court, counsel. There's one issue on appeal in this matter, and that is whether the district court abused its discretion when it ordered Sioux Pharm to de-designate its standard operating procedures from attorney's eyes only or AEO status to confidential, and further ordering Sioux Pharm to produce them in unredacted fashion. How should a trade secret case between direct competitors proceed through discovery and trial? And what happens when the parties' witnesses are their competitive decision makers because they are small business entities? And how does the parties' agreement to a stipulated protective order at the onset impact the analysis? That's what this appeal is really all about. Sioux Pharm uses trade secrets in the form of research, procedures, and processes. It takes great effort to safeguard them, and it memorializes them in the very standard operating procedures that are at issue. The individual defendants, Denhood and Summers, are former employees of Sioux Pharm. Mr. Denhood's the president and owner, and Summers was an officer, and now he's an employee. Sioux Pharm's standard operating procedures, most of them were created or modified after the individual defendants stopped working for Sioux Pharm. The standard operating procedures are not available in the public domain. They're very detailed, they're very technical, and they're very specific.
Were any of them revealed in the Cargill litigation?
Roughly 7 pages were revealed in the Cargill litigation, and in total there are 5 binders that might span 1,000 pages.
Could you address the argument that you allege defendants already stole them, so what's the problem in producing in discovery trade secrets that they already have?
Right. The defendants dispute that contention, Your Honor. They contend that it was a botched break-in and they only had one of our 5 manuals in their truck, and they barely got a chance to look at it. We have evidence to suggest to the contrary. We have evidence that they did possess them previously and that they did modify or alter them previously, including in the middle of the night a couple days after the break-in. So is it possible that they didn't steal all of them? Yes, but we don't know exactly the full extent of the thievery.
And because you don't know which ones they have, you destroy the very secrets of the value of the ones that they may not already have if you were forced to produce them.
That's precisely the case. There's no question that Sioux Pharm's SOPs qualify for AEO, that they meet the definition under the protective order that everybody entered into. And in fact, Eagle similarly designated their standard operating procedures as AEO. Eagle voluntarily agreed to this protective order. Sioux Pharm retained an expert. Sioux Pharm has never seen their SOPs either. It was a fair and level playing field that everybody agreed to until a couple months before trial when, because they had chosen not to retain an expert, their attorneys wanted to share our trade secrets directly with their clients.
Did they I mean, they say they didn't retain an expert because they thought they were only defending the break-in, and then arguably they were sandbagged by these broader allegations that trade secrets were misappropriated by means other than the break-in. How do you respond to that?
My response to that, Your Honor, is that they never asked the court for a continuance. They maintained, after the court allowed us to expand the case, if you want to call it that, back to the 2005 time period, they still sat on their hands. They still said, we're not going to get an expert. They didn't ask the court for a continuance, and in fact, they initially resisted our efforts for a continuance. Courts in various jurisdictions have routinely held that technical proprietary information should not be disclosed to a competitor in a lawsuit. The Safe Flight case cited in our brief, as well as Moore's federal practice, we think is quite instructive in this regard. And one of the issues is the disclosure necessary? There's nothing necessary about the disclosure in this case, and something more than we don't want to pay for experts should be required. My client had to get an expert, and they could have done the same. My client spent millions of dollars on scientific research and analysis to create these standard operating procedures. And when you balance the interests, and it's all about balancing the interests of $4 million worth of trade secrets being handed over to your only domestic competitor grossly outweighs their interest in saving a little bit of money on experts. They could have at least hired a consultant to look at the AEO information and advise their counsel how to proceed. And there are frequently cases where one side chooses for one reason or other not to get an expert. And in those cases, you just attack the other side's expert.
Would they be handicapped defending this claim if they couldn't use their client to help analyze, to work with an expert if they got one, or at least their lawyers? If it's attorney eyes only or attorneys and experts eyes only, don't they lose the ability to get their client input into the defense?
You do, and my client was in the same exact situation, Your Honor. And the relevant cases talk about balancing the interests of the parties, and when you balance it all out, my client had the same frustration. My client several times would have loved to have looked at what they produced, and both sides were in the same boat. And significantly, the defendants have not pointed this court to a single case in which a competitive decision maker was granted access to a plaintiff's trade secrets. And this issue has arisen a lot in the context of in-house counsel who's wanted to view AEO documents. We cited the Ninth Circuit's decision in Brown Bag. I think that case is quite probative. And also the U.S. Steel case, that was the Federal Circuit Court of Appeals case. And in that case, the court stated, it may well very be that a party seeking access should be forced to retain outside counsel or be denied the access recognized as needed. Many courts have found this competitive decision maker issue to be the determinative factor in the analysis. And it was also discussed by the Northern District of Iowa in the highway equipment case. And our case is no exception. Now, to the extent the district court's decision essentially constitutes a modification of the party's stipulated protective order, that was also an abuse of discretion. Protective orders are only entered for good cause. And before modifying, courts must balance the interests of the parties, taking into account the reasons for the protective order in the first place, and whether the party's legitimate interests can still be protected. And that was discussed by this court in the Combs case back in 2009, which I know a few of you were not sitting on the bench at that time. But in Combs, Justice Heck did allow modification to a stipulated protective order, based in part upon the fact that the protective order had what I believe to be a fairly standard provision, allowing the parties to go back to the court to seek relief. But the case was very different. It was a class action lawsuit. There were 23 or 24 million pages of documents at issue, and the court recognized that it was strongly influenced, to quote the court, by the fact that most of the discovery had already been shared with plaintiffs in other cases, and the court was profoundly influenced, to use Justice Heck's words, by a waste of time and expense if the parties in the other lawsuit had to go through the same discovery process. I think the case is very different. However, what this court did discuss in the Combs case is the fact that courts must carefully and fairly consider all the circumstances in a case. When you balance the interest in this case, the pendulum swings very heavily in Sioux Pharm's favor. There's nothing unfair. They entered into the protective order freely and voluntarily. It clearly was put in place to protect both sides, who both had legitimate concerns about their competitors seeing their trade secrets. Sioux Pharm retained an expert. They could have done the exact same thing. Just like the parties in the Phillips Petroleum case, federal court case from Delaware cited in our brief, the parties knew that only counsel and experts would be able to view the AEO information, and they didn't execute that protective order in a vacuum, and they should be held to it. The Bayer case from the Southern District of New York, federal case out of the East Coast, the defendants wanted to modify a protective order, and the court recognized that when parties consent to a stipulated protective order, that consent weighs against modification, and I think the same principle applies in our case.
Could you, at trial, if we reverse and restore the attorney eyes-only protection, how will this work at trial? How will you prove your case? Are you going to have the client decision makers for the defendants leave the courtroom when that part of the case is presented to the jury?
That is certainly what we would advocate for, and there are cases to support that. We cited the Air Products case in our brief, and there's also the Ampco Metal case out of the Wisconsin Supreme Court, which I think is quite instructive. In that case, the Wisconsin Supreme Court said it would destroy the value of the trade secrets sought to be protected and force litigants to choose to either disclose their trade secrets or abandon litigation. And many courts have shielded the public and parties themselves from certain portions, which either would be in open court without the competitive decision makers present, or would be in camera. Thank you.
Thank you as well, counsel.
Thank you, Chief Justice Cady. May it please the court. Counsel, my name is Matthew Connealy, and I am appearing on behalf of Eagle Laboratories and Biokinetics Corporation. Also here today is Michael Murphy, who represents Dana Summers. When I refer to the appellees here today, I'll be referring to them collectively as Eagle Laboratories for the sake of brevity, and when I refer to the appellants, I'll be referring to them as Sioux Pharm. This is an appeal seeking relief from a district court discovery order and the abuse of discretion. The standard of review is for an abuse of discretion. This court has held that such an abuse only occurs when the grounds upon which the order is based are clearly untenable or clearly unreasonable. Furthermore, with regard to discovery orders, the court has specifically said that district courts will be given wide latitude. So I believe that Sioux Pharm has a heavy burden of seeking relief from this order here today. Also, this court has held that the goal of modern discovery is to avoid a game of blind man's bluff at trial in favor of a full and fair disclosure of all relevant facts and issues. And that is exactly what the district court's order accomplishes. This court has also addressed the scope of discovery and trade secrets litigation cases and has held that we should apply a balancing test that seeks to identify relevant and necessary information and allow the party seeking the information to get relevant and necessary information while protecting the other side from disclosing information that's not relevant and necessary. So the normal discovery standard is you get information that's doesn't have to be relevant, it just has to lead to the discovery of relevant information. But this court has said that in trade secrets cases, we will limit it, disclosure to relevant information, and that's exactly what the district court's order accomplishes by only requiring Sioux Pharm to disclose those standard operating procedures that they specifically believe were misappropriated by Eagle Laboratories.
But how do you address their argument that they're not sure what was taken, and whatever they reveal in discovery, if your client decision maker sees it, the secrecy is gone for good?
Well, they'll have the standard protections under the law. The trade secret law is put in place to protect people from any misappropriations. So if our clients were to suddenly start using a procedure that they'd never used before in, say, May of 2015, and they can discover that, then they can prove that case. Also,
how would they know that?
Well,
Because it's your trade secret, you have your trade secrets.
well, I mean, essentially, I'm not sure how they're going to discover that. But moreover, I think that the protective order itself provides protections. It's not just the law. The protective order says that if anybody receives any documents under this protective order, then they have to sign the affidavit saying that they're not going to utilize those trade secrets for anything outside of
If
this
it's
litigation.
something like a standard operating procedure, I mean, once that information is in your head, how are you going to erase that?
Well, I recognize that the courts struggle with that.
And I mean, this really isn't that unusual. I mean, when I was in practice, and this is the kind of case that makes me glad I'm a judge, but it, you know, this attorney's eyes only thing wasn't that unusual, and there were situations where information was limited to the attorneys and the experts, and I couldn't discuss things fully with my clients, and my clients had to take it on faith that I was representing their best interests. I mean, what they're seeking doesn't strike me, and what the order initially provided for doesn't strike me as that unusual.
I think that there's certainly inherent risk in a trade secret misappropriation case. But that risk has to be balanced with the absolute need for my clients to be able to prepare their defense for trial. And my clients will be without the opportunity to properly defend themselves at trial if they aren't able to see this information. You know, we never intended to hire an expert in this case. They tend to sort of characterize it as us making some sort of miscalculation. We never intended to hire an expert because Robert Denhode and Dana Summers are the experts on the production of chondroitin sulfate. You know, nowhere is that more clear than in Sioux Pharm's own motion for a protective order, which is in the non-confidential appendix. I believe it's at page 79, where they specifically state what's unique about this case is that the parties themselves are the only American experts on the production of chondroitin sulfate. So that's the standpoint, that's where we were coming from throughout this entire case. And the protective order was doing its job in allowing for the orderly and low-risk discovery of information throughout the early stages of litigation. They were allowed to turn things over and know that we weren't going to disclose that to our clients without judicial oversight and an opportunity to be heard by the court and make those arguments before we did that. And that's exactly what occurred in this case. The protection order itself, in its own language, allows for modification. It states specifically, nothing in this order will preclude further relief from the court, and nothing in this order shall limit the scope of discovery. That's exactly what has occurred in this case. We obtained further relief from the court on the issues of the scope of discovery. So in the Combs case, when Justice Hecht says he's particularly moved by the fact that the language in this order allowed for modification, we have that in this case. Also, the plaintiffs...
Let me ask you this. If hypothetically we determine the district court struck the wrong balance and that your initial stipulation, attorney's eyes only, is the way this should proceed through trial, but reopen the expert deadline, could you now go get an expert and who would work with you to defend the trade secret claims?
I don't believe that that procedure will allow for the jury to really get at the truth of this case of whether misappropriation occurred. And you only need to look at their expert report to see what are these expert reports really going to conclude. Their expert report says, well, I think they stole it because it looks substantially similar, but I don't really know because I can't see the actual details because it's still redacted. Now, presumably it might be unredacted at some point, but our expert report presumably could say not much more than worst case scenario, these two things look a lot alike, but conceivably these people could have came up with it on their own. That's it. That's all they could say. Our clients would still be left without the ability to specifically describe to the jury how they came up with that procedure on their own. They could testify generally, but without knowing what they stole, how can they tell the jury what they did to counter the allegations in this case?
Well, couldn't they testify what they did to create their own standard operating procedures, but if they leave the courtroom, but you're still in there to cross-examine Sioux Pharm's expert?
They could describe their procedures very generally, But without knowing the important issue, how can they really adequately develop their testimony for trial to convince the jury otherwise? So say, for example, that the hot button issue is Agent 15, hypothetically. Well, as an attorney, I can't go to them and say, hey, you really need to talk more about Agent 15 without running the risk of violating the protective order. So if we just go, it's essentially blind man's bluff at that point. We're going to generally question our client about their procedure. They might glance over a very important issue, and the jury will be left to say, well, they didn't really tell us how they did that very important thing, because they won't know what the allegations in the case are. To me, this case is just as much about narrowing the issues for trial as it is about discovery or disclosure of this information. Contrary to Sioux Pharm's point of view, the district court's order really does force them to pick and choose which standard operating procedures were actually misappropriated. And they need to pick and choose those to present to the jury based upon evidence, as opposed to just saying, well, we have 300, they might have all 300, we don't know because we don't really have any evidence of what. They need to come to court with the evidence for the jury. And this order narrows the scope of the inquiry for trial, and that's appropriate. They truly want to go to trial, throw everything up against the wall and see what sticks, but the judge in his order has exercised his essential gatekeeping function by forcing them to narrow those issues. And I believe that if the district court's order is affirmed, it will in effect appropriately narrow the issues for trial. They will not unredact and de-designate all 300 because they know that we don't actually have all of those SOPs. They will be forced to pick and choose which ones are important for trial, and at that stage, the issues will be appropriately narrowed for trial. We believe that for that reason and the others that I've stated, Judge Hoffmeier's order was not an abuse of his wide latitude of discretion on this issue, and we'd ask that the court affirm. Thank you.
Thank you as well, counsel. Mr. Osborn, rebuttal.
Just a couple of quick comments, Chief Justice. Please, the court. It's up to a jury to decide which trade secrets they stole. We consulted at length with our expert. This is not a case where any narrowing of the issues needs to be done, any further narrowing. Whatever they stole, whatever they misappropriated, they stole and misappropriated.
Ask you a question, Mr. Osborn. I think, you know, Mr. Connealy makes a point that I'd like you to respond to. You know, if this were a patent case, which it isn't, then, you know, arguably your client's, or their client's intent wouldn't matter if you were suing them for patent infringement. And so if there was a protective order, you could say that restricted the clients on the other side from looking at your client's processes. You could say, well, they don't really need to see that because they're either infringing or they're not, and an expert can weigh in. But in a trade secret case where you have to show misappropriation, that is sort of an element of fault or affirmative action on the part of the defendants to utilize the trade secret, their argument is, well, we really need to see what we're accused of utilizing in order to frame the defense, and having that go through an expert won't really work. I mean, how do you explain it? And many of your cases don't involve that.
Thank you. Many of the cases are, in fact, in the patent arena, and I think one of the key distinctions is that in our case, we have a genuine fact issue, which is for the jury's province, in terms of what actually did they factually get their hands on, what did they view, and I think that's a key and critical distinction in this case, and that's why I think the gatekeeping role, if you want to use that term, sort of evaporates on the judge's end of the equation, and it transfers over to the jury to decide, to hear the evidence, and decide, okay, of these 5 binders of standard operating procedures, do we think they only actually stole 5 of them? And if that's the case, then the jury can award damages accordingly. Just a couple other brief points. There's no evidence at all that the defendants couldn't get an expert. My office found an expert. There's no evidence before this court that they tried to find an expert, and that's because they didn't. And we timely designated an expert, so in response to the inquiry regarding the possibility of opening up discovery and allowing them to get an expert, obviously that would be a better approach than insisting that my clients hand over all their secrets to their only domestic competitor. But it would seem that they've waived or should be stopped from making that argument when they not once have asked for experts. As soon as they knew that this case was going back to 2005, they not once did they ask the court, can we get an expert? Can we push this out so we can get an expert? And even though we ended up here through an interlocutory appeal, it would seem to me that the process shouldn't open up, and depending on how this court rules, we should go back to court, the district court, and move forward from where we were when we left off.
How do you respond to the comment made by counsel, however, that the parties here, the owner and the other employees there, are in fact the best experts that they're ever going to find in a case like this? How do you respond to that? Why do they have to go out and hire someone else who's an expert, I guess, but not as expert as they are in this same litigation? So how do you respond to that?
You bet. I will assume, for sake of argument, that they are qualified as experts. I'm not. I think that might be debatable given their background, but we were very easily able to find an expert who specializes in chondroitin sulfate, and while my clients are PhD scientists who are very educated, I think their qualifications are in the court's record. I'm sure that they would be immensely beneficial to our prosecution of this case. But we realized long ago, that that was not an option that was available to us. And finally, in terms of the redaction, briefly, they claim that we redacted all the key information, but our expert looked at our redacted SOPs and their redacted SOPs, and concluded from what he could see that it was plagiarism, and he actually used that word in his report. So we would also urge the court to not order our client to unredact any aspects of their operating procedures as well.
Since this issue involves a balancing of interests and our standard review is an abuse of discretion, would we have to conclude that the defendant's interests are not much at all, that they don't have much at stake here?
No, I think that when you're balancing, the balancing test requires two things. You look at the purpose of the protective order in the first place, which in our motion for protective order, we explain very clearly. Both sides have highly sensitive information that they don't want the other side to see. And then secondly, you have to balance millions of dollars of research against an unknown amount of money to consult with somebody in the industry. And I think that's the balancing that has to occur, Chief Justice. And again, we think that balancing test swings heavily in our favor.
Thank you, Mr. Osborn.
Thank you.
The case then is submitted, and we'll next hear the arguments in the Summit Nutritionals case.